them.
Okay. All right. So I've got that in my hand as well. Mr. Jamal, you can proceed with your motion.
Yeah, so the motion is primarily based on 2.116C10. Included with our motion for summary, we've provided detailed account statements that breaks out the usage of the account from a zero balance to the balance we're seeking in our complaint. We show not only usage, but also payment made towards the account. Those statements were sent to the address we currently, I believe, service was made to defendant at. Given those facts, we are seeking a motion for summary be granted in the amount that's requested. And I would just indicate too, defendant has referenced seeking a wedding signature, additional contract terms, etc. However, usage of an account constitutes agreement for liability on that account. These statements specifically indicate that this account was sent and used without objection by defendant, and therefore liability should exist.
Okay. And the amount, it looks like, just on the, I don't want the court cost, but it looks like the damages for the card, the account itself is $2,349.65. Is that the right amount?
That is correct, yes.
Yeah. All right.
And that should be supported by the last statement we have included in our packet. Also has a balance of $2,349.65.
So let's see that here. Way in the back here.
The payment due date on that statement is February 17, 2025.
No, thank you, Jamal. I was just looking for the last, here it is. Yeah, I'm sorry, February 17, 2025. That's the last one I'm seeing. Yeah. Okay. Mr. John Michael, any response?
Well, actually, kind of my paperwork should stand on its own. There was billing statements are self-generated and lack foundation and are inadmissible as live testimony and of a custodian with a personal and no one of personal knowledge under MRE 8036. Prior payments do not establish a contract liability. My realization of the fact that the Citibank, Best Buy, and or the law firm have provided any adequate compensation to complete the contract, and nor did they express the fact that they were changing my standing from the creditor because it was my credit worthiness that created the substance for the loan. They were paid. That was basically conversion from me, from the creditor to the debtor. Under trust law, it converts my standing from the beneficiary to the trustee. And I affirm that there is no standing that they have to file a claim against the living man. And if you're refusing
Mr. Michael, from what I hear, though, you're acknowledging that this is your account.
I am not acknowledging that it is my account.
Well, you just said that they used your credit standing to form the basis of the contract originally.
Yes, that is true.
So how are you not?
If it was my financing, the credibility that funded this loan, how do I owe them any money?
Sure, I quite understand, Mr. Jamal.
I'm not hearing you.
The only response I would have, Your Honor, is he does reference admissibility. I think Michigan law is pretty clear that when it comes to a motion for summary, documentation is admissible to the extent that it would be admissible at a trial with proper foundation being laid. Foundation does not need to be laid at the motion for summary stage. There is no need for testimony or additional authentication. So the statements are properly before the court at a motion stage.
Okay. I'm just going to take a brief recess off the matter. I'm going to review the statements that have been supplied. Nope, that's it. We're done. Nope, I'm going to make a decision. Hold on. I'll be right back on. Sir, you told me that already. I'm going to take a brief recess. I'm going to review all the pleadings in its entirety, and I'll come right back on. Okay, we can come back on the record with Citibank versus John Hayes. I've had a chance to review all the pleadings and documents that have been provided by both sides. This matter. This is a motion brought in part by MCR 2.116C10. This motion may be granted where there is no genuine issue of material fact and which would entitle the movement to a judgment as a matter of law. In determining the factual support for this claim, I have reviewed all of the pleadings, affidavits, any depositions, admissions, and other documentary evidence that's been provided today. Should be noted that the non-movement party, that being John Hayes in this matter, does not rest merely on allegations or denial of the pleadings, but also must demonstrate by documentary evidence that there is a genuine issue for trial. I do find, after significantly going through all of the documents that have been provided to me today, the consistency of the statements that went out, starting with a new account through Citibank on this account, and this account was, let's see, where is it? Card ending in 8271, John Hayes. You find that there was this card was used over a significant period of time. There were also payments made over a period of time. The address was sent, all of these documents were sent to, these statements were sent to John Hayes at 5141 Flagler Street, Flint, Michigan, 48532. Do find it's consistent with what's been complained of, the amount owing. The final statement that has been complained of today, February 17th, 2025, shows a balance owing of $2,349.65. And based upon all the documents, all the pleadings, there's no genuine issue material fact. Grant motion for summary disposition to Citibank for damages $2,349.65 plus court costs that are being requested. Mr. Jamal, I thought I saw somewhere in here.
There was a proposed judgment submitted with the motion.
Okay. Just gotta find it.
Everything's still in order. It's typically page 7 or 8.
If it's still in order, does that mean I may have torn it apart? Is that what you're telling me?
Potentially.
I'll find it here. It's probably the last page. I think I saw it somewhere in here. And military affidavit. I got everything here.
It's typically right after the military F.
Yeah. See, for some reason, we get all these statements that are attached too. As usual, I can find it right off the bat. And this is one's that I can.
If needed, I can email.
Do you have the figures in front of the court costs?
I do.
What do you have?
Filing fee of $75.
Okay.
Motion fee of $20.
Okay.
Service fee of $58.68.
68.
Total is $153.68. Add that to the damages amount referenced, and total balance is $2,503.33.
Okay. Oh, here, when I found it right at the end. There it is. I do have the proposed judgment showing the amount I asked for damages originally, the total on February 17th, $2,349.65, plus the court cost is just recited for a total of $2,503.33. Judgment for plaintiff in that amount based on summary disposition. Answer 2.116C10. I'll sign that proposed judgment and send both of you a copy. Okay?
Thank you all.
All right. Good luck to both of you.
I object, Your Honor.
Okay.
I'd like to make a comment that you're making a judgment based on no contract. All the 6 requirements of a contract were not met. I came to the realization that there was no consideration and no risk and not full disclosure. And you're still going to judge against that without a contract?
I'm not taking questions, sir. You can put your statement on. Is there anything else?
I let my paperwork stand again. And I will have to file for an appeal under Article 10 of the Constitution. This controversy is greater than $25. I will be filing in a court of appeal.
Leave it at that. And I've signed the summary disposition judgment I just ordered. And we're all set.